Before we get started, we'd like to thank Liberty Mutual Surety for sponsoring this episode of Let's Get Surety. Liberty Mutual Surety provides all your bond needs, all in one place. For more information on Liberty Mutual's breadth of surety products and solutions, visit www.libertymutualsurety.com. Now on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Welcome to this episode of Let's Get Surety. So today I have with me my co-host, Mark McCallum, CEO of NASBP. Hey, Mark.
Hey, Kat. It's a pleasure to be with you again.
Thanks for being on with me. And today we're going to be talking about False Claims Act liability risks. It's a pretty serious topic. And to do that, we have with us Martha Perkins, NASBP's General Counsel. Hey, Martha.
Hey, Kat. Hey, Mark.
And we also have Greg Horn, and he's a contract surety underwriting officer with Liberty Mutual Surety. Thanks so much for being with us, Greg.
Good morning, and thanks for having me.
Greg, before we get started, do you want to just tell us a little bit more about yourself and about Liberty Mutual?
Sure. Liberty Mutual Surety is part of the Liberty Mutual Group, the largest international surety underwriter. And I've been in this industry for about 35 years, starting out with Aetna through Travelers, CNA, and been with Liberty since 2006.
Okay. So to kind of get us into this and talking about the False Claims Act, Martha or Greg, do you want to start out by just telling us what is the False Claims Act and why is it important in the surety industry?
Well, I can start out with giving some background on the False Claims Act, but I'd like to start with a federal construction contracting seminar that NASBP sponsored in 2015. 5 attorneys from the law firm of Picard and Abramson gave that on hot surety topics. And one of the topics was fraud, the new mantra of federal contracting and how it will affect the surety industry. And during that seminar, they said sureties and bond producers are going to be at risk for False Claims Act liability. There was a silence that went through the room and then huge amounts of nervous laughter and kind of hooting and that kind of thing.
Yeah.
Well, it was a nervous-making sort of thing, but in fact, it has come to fruition. So I remember that seminar and think about it often because we are now, that was a prescient prediction and we are in it now. But the False Claims Act is an act that was first enacted in 1863 called the Lincoln Law to address false claims for the federal government, the Union government at the time. War profiteers were selling boxes of sawdust instead of guns to the Union Army, selling cavalry horses several times over, semi-dead mules, rotten food, and Congress passed the False Claims Act. It's gone through several iterations since then, but it took a huge turn in 1986 and got much more teeth in it. And it is basically the government's top monetary recovery tool to address fraud, and there are billions of dollars recovered annually, billions of dollars. And there have been a number of settlements and lawsuits and claims against contractors and subcontractors up until about 2015, 2016, when sureties and then bond producers got included under its ambit. Okay, so what is it? It creates liability for any person who knowingly submits a false claim to the government or causes another to submit a false claim or knowingly makes a false statement to get a false claim paid. Now, that knowing requirement is actually much broader than it sounds because it can consist of, and this is in the statute, actual knowledge, deliberate ignorance of the truth, or reckless disregard of the truth. In other words, almost anything that makes something untrue and the government has to pay out for it. Then you've got reverse false claims, which means that there is liability for one who does not pay the government money it is owed. So there are a lot of different ways that can result in liability in the construction industry. It can concern set-aside contractors, those who certify that they're eligible for set-aside programs, and that would include anything from 8A programs, women-owned small businesses, service-disabled, veteran-owned small businesses. And it's really onerous because the statute provides that you must pay a civil penalty for each false claim. Now, the amount of the civil penalty was updated by the Department of Justice last year. It is now about $12,000 to $23,000 for each false claim. And if an improper set-aside contractor has lots and lots of pay apps, each one is going to be considered a false claim. So that'll be potentially a $23,000 penalty for each of those pay apps. It's really onerous. And then the government has the starting position that the amount of damages is treble the amount of the contract. So if it's a $50 million contract, the government says you owe us $150 million because you said you were a proper set-aside contractor and you're not. If you certify that you put a certain amount of fill in a demolition contract, filling up a hole in the ground, and you didn't put the right quantity in, that's a false claim. If you didn't put in clean fill, but you put in the demolition material instead, that is a false claim. There are untold numbers of ways that a false claim can be committed. Now, there are ways that different cases can be brought under the False Claim Act. You have the key tom provisions, which basically are whistleblower provisions. Key tom is nothing more than an abbreviation of a Latin phrase that means he who brings an action for the king as well as for himself. And what's interesting about a key tom whistleblower is that they tend to get a fairly large percentage of the government's recovery. It can be anywhere from 15 to 30%. So the key tom plaintiff can bring the action on behalf of the government, or the government can intervene and take it over. How does the government find out about these? Often the government will go in and look at underwriting files or producers' files when they are investigating a contractor, and they may find something that they find very interesting. The whistleblower is usually an insider, either a current or former employee who maybe has access to the confidential information that the employer is defrauding the government, or making allegations that the employer is defrauding the government. So that is, in quick, the False Claims Act. And
Martha,
I'm sorry, go ahead.
Well, Martha, you had brought up that the False Claims Act's been around for quite some time. And then you also mentioned that now all of a sudden it seems like sureties and bond producers might be in the sights of the government. What has occurred that has created that kind of focus on the surety industry with respect to this act?
Probably a number of things. The government has been doing a lot more fraud enforcement the past few years, just in general, against financial institutions and healthcare providers, more and more against contractors and subs. The government is always looking for deep pockets, and they're trying to protect the set-aside programs. And so I think by going after contractors and investigating the files of sureties, they're looking, wait a minute, it's an insurance company or a surety company. Maybe they have deep pockets too. And they're trying to put the burden on bond producers and surety companies to use their what they call superior knowledge, or know or should have known that by bonding or trying to obtain bonds for a alleged set-aside contractor, that they should have known that that set-aside contractor was a shell company or was an improper set-aside contractor.
So great. How big is the federal set-aside contract market? Is this a big piece of the market?
Yeah, it certainly is. I mean, you got to remember what we're talking about here. The SBA sets their set-aside contracting goals annually, and it applies to their several set-aside designations, which include 8A contractors, small disadvantaged businesses, women-owned small businesses, hub zone contractors, service-disabled vets, and small business concerns, which are determined by size. From a historical standpoint, the SBA set those goals at 35%, 30%, and 39% of the entire federal construction budget for 2018, 19, and 20. And to put some numbers around that, in 2019, the federal government awarded $132 billion in set-aside contracts. And I think what's important to understand is, what are we looking at today? I think, we are currently in a situation where we're in the midst of a health crisis that has caused a financial crisis. Historically, infrastructure spend has been a major tool that the federal government employs to get out of any kind of financial crisis. We've recently experienced some pretty significant social unrest, and we now have a new federal administration. So I think those factors, when all aligned, I think it's reasonable to expect that the actual set-aside construction market will grow. And when anything grows, it attracts new people, new players, and attempts to do new ways of doing business.
And I guess as a set-aside contractor, you're making a representation of the government that you qualify under a particular program. And Martha, as you said, I guess if that doesn't turn out to be entirely accurate, then that can form the basis of a False Claims Act allegation. And then people who are looking at that transaction, that party, if they are making a representation, can they get caught up in that web as well in terms of the allegation?
You talking about the bond producer?
And the surety, as a matter of fact.
The bond producer and the surety can get caught up in it. I think that the DOJ and the U.S. attorneys first went after surety companies, then realized, wait a minute, what are these people called bond producers? Let's go after them as well. And they absolutely can get caught up in it. So it's important that everybody understands this. I'd like just to mention a couple of cases, False Claims Act cases that have occurred the last few years that kind of are object lessons in what not to do. And I'll also say that just because the government makes allegations doesn't necessarily mean they are true. But a lot of sureties and bond producers would rather settle with the government than to go through a long, drawn-out, very public trial. That is a business decision each one has to make.
Yeah.
But in one case, a surety had to pay over $1 million to settle false claims allegations because it bonded a contractor in an 8A fraud scheme. And the government alleged that the surety knew or should have known that the construction company was in violations of the 8A program requirements. The U.S. contended that it knew or should have known the company was not controlled by a socially and economically disadvantaged individual. It was affiliated with and controlled by another entity. And then, even though it knew it, it continued bonding and therefore allowed this fraudulent contractor to continue under the preferences in the 8A program. It's almost a but-for standard, but for the bond producer seeking and the surety issuing bonds, these fraudulent entities would not be permitted to participate in these set-aside programs. And the government's taking these incredibly seriously. Now, in this particular settlement, there were only allegations and there was not a determination of liability against the surety in that case. Typically there is, but there was not in that case. The other is the now infamous Skolic case, which we are all familiar with. In Skolic, a former employee of a construction company filed the FCA lawsuit against several companies, the principals, bond producers, and sureties who bonded federal construction projects. Now, the complaint alleges that the principals established shell companies to get HUB Zone 8A and service disabled veteran and small business status in order to get the set-aside contracts. The court said on a motion to dismiss that the bond defendants, the bond producers and sureties, it was sufficient to survive a motion to dismiss. Now, at this point, the court has not said that the allegations are true, but they say if they are true, then there is FCA liability. So everybody's watching the Skolic case. It's still ongoing. There's been discovery. There is a summary judgment schedule. Supposedly, the summary judgment motions are going to get filed and briefed sometime in February or March, and we're hoping in the next few months to get a decision on those if they don't settle in the meantime. But this is the U.S. District Court for the Federal District, which is a very important one, that is saying that sureties, agencies, and bond producers can be subject to FCA liability. So this is an extremely important case. Greg, I think you were going to talk about another case.
Yeah, earlier this year, the Department of Justice actually settled an investigation of an insurance agency, one of its agents, and two of the agency's contractor clients for False Claims Act violations that arose out of set-aside contracts that were issued to one of the contractor clients. After the investigation, collectively, the agency and the two contractor clients paid the government $4.5 million to settle those claims. And what's really telling is, as part of the settlement, the government issued a press release, and also it was incorporated in part of an inter-office memo sent to the other district agencies that said that the agency and its agent knew or should have known during their relationship with the set-aside contractor client that the set-aside contractor client and the non-set-aside contractor client were affiliated in violation of SBA regulations, and that those companies took steps to hide their affiliation from the government to obtain and receive payment on the government set-aside contracts. The agency's decision to help the set-aside contractor client obtain bonding was critical action furtherance of the two contractor clients' fraud on the government, and served as a substantial factor in causing the set-aside contractor client to submit false claims for payment to the United States government. Without surety bonds that the agent and agency helped the set-aside contractor client procure, the set-aside contractor client's fraud would not have been possible. That was the press release that the government released.
That's interesting.
You know, Greg and I both wanted to point out that and I know you will hear this, that attorneys are constantly trolling for whistleblower lawsuits. So the bar is out there trying to obtain, because they're going to get a huge cut of whatever percentage that the Keaton plaintiff receives.
Greg, it sounds like there are some profound repercussions for the way you underwrite a set-aside contractor or, contractors working on a set-aside contract. Do you care to kind of elaborate maybe some of the things that you guys are cognizant of when you're underwriting in such a circumstance?
Well, I don't know that it's cognizant. I mean, obviously, we're going to do everything according to the law, but you really have two flavors in terms of what's coming up. You have the contractor that portrays themselves falsely as a set-aside contractor or fraudulently, and those are always the bad actors, and you're never going to get rid of them. But the other instance is contractors where who are trying to get access to this marketplace through other means or through legitimate actual federal side contractors. And the way they've been doing that historically was with teaming agreements and some other things that were all legitimate and what have you. But it's important to understand that when someone signs a contract, they become part of the contract and assume all the rights and responsibilities and remedies in the contract. That's what we call privity of contract. And at some point in their career, every contractor will encounter a situation where they're guaranteeing a contract they're not a party to. We call that third party indemnity. Contractors extend their indemnity to joint ventures, guaranteeing the performance of the joint venture partner. They'll do it to facilitate a continuity transaction in the sale of a business. And they might even do it to help a relative or a loyal project manager get started in a business. And except in the situation of a joint venture, the third party indemnitor doesn't have privity of contract. They're assuming the responsibility for the outcome of the contract without having any contractual rights or remedies. They have no privity of contract. But now it's important to understand, and this is the basic underwriting tenet, profitable contractors determine their destiny through the application of controls. They have to ensure successful performance, make sure everyone gets paid, and step in to change the status quo when things aren't going very well. So when a contractor has privity of contract, the path to those controls is granted by the contractor and is very straightforward. When a contractor provides third-party indemnity, usually they'll create a path via some sort of side agreement, the joint venture agreement, the buy-sell agreement, the continuity transaction, or some other agreement where they can step in and take control of the situation when things aren't going as planned. The issue is on a federal set-aside contract, when they provide third-party indemnity for that, the affiliation and ostensible subcontractor rules associated with the False Claims Act prohibit any sort of side agreement that leads to control. So absence of privity of contract, it's a fairly substantial argument against providing any kind of third-party fronting arrangements in federal set-aside contracts. And if you look at it in the bigger picture, the surety's primary function is to pre-qualify the contractor, back our decision with our balance sheet via the bond. So whenever we get a request to front a bond for another party on a third-party indemnity deal, it implies the principal on that bond can't secure the bond on their own merit. So the surety industry is highly competitive. And when a principal can't secure a bond, that says something. And when a contractor is willing to provide third-party indemnity, the contractor needs to satisfy themselves on two questions. The first question is, what can I do that the surety can't to prevent or fix a problem if it occurs? And secondly, what do I know that makes me smarter than the entire surety industry?
So you've talked a lot about the risks associated with the False Claims Act. Is there anything that stakeholders can do to kind of mitigate that risk that's associated with False Claims Act?
Kat, that's a very important question, a good one. These are common sense controls to reduce the False Claims Act risk. Basically, train producers and surety company professionals to conduct government contracts and False Claims Act training programs. Train surety professionals on red flags. In particular, confirm the eligibility for set-aside contracts from principals and producers. I think it's really important to also talk for bond producers and sureties to talk to their contractors and subcontractors about False Claims Act risk. One thing I want to make sure to mention is that NASBP was asked by AGC to have a presentation at their Surety Bonding and Risk Management Conference, June 2nd to 4th in 2021, on the False Claims Act. And we're very excited to have two attorneys on our Attorney Advisory Council, Tim Heffernan from White Teeter and David Robbins from Jenner and Block, who are going to talk on that, just exactly what Greg and I have been talking about, and how to mitigate those risks. I think it's very important to involve legal counsel, both internal legal counsel and outside legal counsel, to make sure that due diligence is sufficient.
Yeah, and I think it's important too that we're looking at a limited capacity in terms of the number of set-aside contractors that are out there and that exist. And we're looking at a potential expanding market. So if people are looking in order to help or assist or some of those set-aside contractors to get involved and to help them through perhaps some of those jobs, the official SBA Mentor Protege program is the right way to do it. It is a program that basically a formal training program between a larger contractor and the set-aside contractor. It can exist for 9 years, and it allows many of the affiliation and ostensible subcontracting rules to be put aside, because through the mentoring and the programming of it, you enable and grow that small set-aside contractor in terms of training. There is a lot of paperwork involved. It takes time to get enrolled and approved in that particular program. So if contractors are looking at, if they're not set-aside contractors but want to help a set-aside contractor, they should be looking and start that paperwork and that process right now.
Well, it sounds like education and training is a really important aspect or piece of this, so that everyone can get the information they need to properly handle the situations they might find themselves in. Martha mentioned that session coming up that NASBP is doing on the False Claims Act at the AGC Surety Bonding Conference in June. What's Liberty doing on this, Greg?
Well, we've published a white paper in terms of explaining all the risks and what is exactly going on in the marketplace. And also, as an attachment to that, we've attached a lot of actually Martha's articles and other articles and cases that are available in the industry. That's been sent to all our producers. If you have not received a copy, please reach out to us and we'll make sure you get a copy of that. We're also preparing a training program that our people can actually deliver to the local surety associations to make sure the sureties understand too what the risks are associated with this particular program.
Do either of you have any final thoughts on the False Claims Act risk management that you want to share?
Kat, I just have something short to say.
Sure.
That sureties and producers are incredibly and extraordinarily good at understanding and mitigating risk. So I think if they exercise proper due diligence in training and educating themselves, the folks that work for them and their contractors and subcontractors, the risk is going to be vastly mitigated. I'm confident of that.
And I would agree. Set-aside contracts, are a way to grow small disadvantaged businesses, and it is needed in the marketplace. But you need to do it right, and everybody needs to be disciplined and play by the rules. And education is the key to that.
Well, thank you guys both so much. That was really interesting information around the False Claims Act and specifically around federal set-aside contracting. Thank you both for being with us. I hope we can have you guys back on another episode.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just wanted to thank Liberty Mutual Surety again for their generous support of sponsoring this episode of Let's Get Surety. Liberty Mutual Surety provides all your bond needs all in one place. For more information on Liberty Mutual's breadth of surety products and solutions, visit www.libertymutualsurety.com.